From Kern Government Television, welcome to this week's Kern County Board of Supervisors meeting, originating from the County Administrative Center located at 1115 Truxtun Avenue, Bakersfield, California. Kern County's vision is to create and maintain a customer-centered county government designed to garner the confidence, support, and trust of the people we serve. Today's Kern County Board of Supervisors meeting will convene momentarily.
Good afternoon. Board will reconvene. Welcome to the Tuesday afternoon PM session of the Kern County Board of Supervisors on this, the 23rd day of April, 2013. So, Madam Clerk, would you please call the roll?
Supervisor Gleason.
Here.
Supervisor Scrivener.
Here.
Supervisor Maggard.
Here.
Supervisor Couch.
Here.
Supervisor Perez.
Here.
We're happy that you joined us this afternoon. We have a number of items to conduct for the people's business this afternoon. And we're going to start by hearing a report on actions taken in closed sessions from our County Counsel, Teresa Goldner.
Thank you, Chairman Maggard and members of the board. There were several matters that were heard in closed session today. Items number 29 through and including 36 were heard. No action was taken on any of those items. With respect to item number 37, the board met in closed session to confer with counsel and staff concerning the matter of Kimberly Minor versus County of Kern. This is Workers' Compensation Appeals Board cases ADJ 204-2743, ADJ 731-239, and ADJ 1159917. These were filed by an applicant, Kimberly Minor, for alleged injuries arising out of her employment at Kern Medical Center. By unanimous vote, the board approved settlement by way of a compromise and release for up to $200,000. Further authorized the auditor controller to issue warrants as directed by County Counsel, authorized County Counsel to present the settlement to the Workers' Compensation Appeals Board, and to execute all necessary closing documents. Item number 38 on today's agenda, the board met in closed session to confer with counsel and staff regarding the matter of City of Ridgecrest versus Mata Santos. This was Sacramento County Superior Court case number 34-2013-8001438. In this matter, by unanimous vote, the board authorized County Counsel to enter into a stipulation whereby the county is excused from further appearances in the matter and may file an answer as the need arises, and agrees to abide by the eventual decision of the Sacramento County Superior Court. With respect to item number 39, the court also met in closed session today with counsel and staff regarding the matter of La Princess Hawkins versus County of Kern. This is Workers' Compensation Appeals Board case number ADJ 4237699. This matter was filed by the applicant, Ms. Hawkins, for a July 3rd, 2000 alleged injury while employed at Kern Medical Center. In this case, by unanimous vote, the board approved settlement authority by way of a compromise and release in the sum of $86,000, authorized the auditor controller to issue warrants as requested by County Counsel, authorized County Counsel to present the proposed settlement to the Workers' Compensation Appeals Board, and also to execute any necessary closing documents. And if I didn't already say it, with respect to item number 38, that was also by a unanimous vote. And that concludes my report.
Thank you, County Counsel Goldner. We will next deal with our consent agenda this afternoon. It is rather lengthy. Consent items are routine in nature for the most part, and generally we vote on them all at once. So I'm going to go through 40-something consent items in a kind of a compacted, abbreviated fashion. They're indicated on our agenda with a CA, meaning consent agenda item, and we typically vote on them all at once. If you would like any of those matters to be pulled so that it can be voted on separately because that's of some significance or importance to you that you think is not routine, it warrants that further discussion, I'm going to look to you in a moment. If you raise your hand, I'll notice who you are, and I'll find out what item that is if you'd like me to pull that. So the consent agenda items begin on page 9 of our agenda this afternoon, and all the items 4, 5, and 6. But I need to read into the record that item number 5 has a correction. If you're looking at your agenda, item number 5, the recommended action is in all bold caps, capitalized letters. The last line of that says, after the colon, semicolon, direct clerk of the board to record. Those words are not necessary, and they will be struck from the item. So the item number 5 remains on consent with the correction that direct clerk of the board to record will be removed. So all the items on page 9, 4, 5, and 6. On page 10, all the items 7 through 9. On page 11, item number 11. On page 12, items 12 through 16. On page 13, all the items 17 through 21. On page 14, all the items 22 through 26. Page 15, all the items 27 through 32. On page 16, all the items 33 through 38. And on page 17, the remainder of the items 39 through 43. All of those items are on consent and will remain so unless somebody from the audience or the board would like to pull them for a separate vote. Is there anybody here who would like to pull one of those items for separate consideration? I don't see anybody raising their hand. Does that mean? Nope, there's nobody. Okay. So, colleagues on the board, are there any of those matters you'd like to pull for separate consideration?
Motion on consent.
Thank you, sir. Second. So we will, the motion is to approve consent with that one correction to item number 5, wasn't it? 5, yes, thank you. Okay, please cast your votes.
The vote is all ayes.
Thank you very much. We offer an opportunity every time we meet for the public to speak with us about any matter that they would like. If it's on our agenda, for example, there are a couple of items that will be of significant interest to some in the crowd. We'll talk about those when they come up on the agenda. But if there's an item that you'd like to talk to us about that is not on our agenda, we offer you the opportunity to come forward now and make comment to us about something that we're not going to otherwise discuss this afternoon. Does anybody wish to make comment to the board? Nope, looks like... I want to make sure that person wasn't coming forward. So did anybody want to make comment to the board about any item this afternoon? That's not on the agenda. Okay. Then we'll close public comment and come back to the board. Colleagues, do you have any announcements or reports or comments you'd like to make? Supervisor Couch.
Thank you. I'd like to make a referral to the CAO's office and to County Council. It would be a request for review of all county boards and commissions to look at their continued need and effectiveness of each and the potential combinations and or decrease in the number of committees and potential savings of staff time. Thank you.
Okay. Thank you.
Second.
A motion and a second to refer that to staff. Does that seem clear, Mr. Nylon? Is it Nylon that you're particularly addressing that to? CAO's office?
CAO's office and I would assume County Council as well.
Oh, and County Council as well. Okay, very good. Okay. Go ahead and cast your votes.
All ayes.
Very good. Thank you very much. Any other comments or remarks by members of the board? Okay, let's move on then to item number 3. This is under Development Services Agency. This is a request from FRV Orion Solar project to eliminate some road reservations and some other matters. Ms. Oviatt from our planning department is going to explain to the board this matter and initiate the discussion. So, Ms. Oviatt.
Good afternoon, Chairman Maggart, members of the board. I'm here today. On my right is Jacqueline Kitchen, who is the supervising planner, and Craig Murphy on my left, who is the division chief. They have been the processors of this environmental impact report and project. This item is a general plan amendment, a conditional use permit, and a petition for cancellation of a 265-acre Williamson Act land use contract for implementation of the FRV Orion Solar project by FRV Orion Solar for 20 megawatts of electricity. This item was continued from your March 19, 2013 general plan window board hearing. This is a large-scale commercial solar project. It's located 7 miles south of the community of Lamont. The project site is 200-acre portion of a 265-acre project site. It is accessed from Herring Road and South Edison Highway, from Highway 99, East Bear Mountain Road, and South Weed Patch Highway. It's located in an agricultural area adjacent to above-ground transmission lines and substations. There are 2 residences located within the vicinity of the site, both located on land zoned agriculture. Project request for the general plan amendment is to remove future road reservations internal to the site, specifically only in Section 17. So we do reserve those midsection and section lines for future roads. In this case, we would be removing that reservation so that they would not have to set the panels back. The project facilities at the site would include the photovoltaic modules that use a tracking system, the mounting structures, the inverters and the transformers, the electrical system and distribution. So the lines that go from the solar project to the PG&E stations are private intertie connection lines. They are constructed and owned by the project applicant. A generation step-up transformer, an on-site switchgear building, weather monitoring equipment, fencing, and an on-site substation. They are proposing to use a off-site operations and maintenance building and warehouse that was already approved by your board at the Regulus Solar project near Edison. They would be interconnected to the 70 kV Weed Patch San Bernard transmission line, and they would have a power purchase agreement with Pacific Gas and Electric. We have asked the applicant in their presentation to your board to address capacity issues and other issues regarding what, if any, upgrades they need to make to this proposal. We've included in the staff report a detailed representation that we know of that they would only be replacing what they call reconducting certain lines that are required to serve this project. We did prepare an environmental impact report. It was in full compliance with CEQA. It includes the notice of preparation, the draft EIR, which was circulated for 45 days, and response to comments. Your board received all of these documents while they were being circulated to the public, and so you have had over a year to review these documents. The final EIR comprises 3 volumes, 45 mitigation measures to reduce significant impacts. Mitigation measure monitoring program is attached for your review and consideration in the staff report Exhibit C. We have provided detailed discussion of the EIR and impacts in the staff report. They determined that the project and cumulative impacts remain significant after all feasible and reasonable mitigation for the following areas: aesthetics, agriculture and forest resources, temporary construction impacts to air quality, biological resources because of the cumulative impacts, and temporary noise during construction. We did include 4 alternatives and determined that Alternative B, which would be only rooftop industrial and commercial solar instead of using ground mount, was the environmentally superior. 12 comments were received on the project during the draft circulation of the draft EIR. We did provide you detailed responses and clarifications to any mitigation measures in Volume 3, Chapter 7, Response to Comment, which was given to you in March. Numerous comments on this project during our public comment phase have been received from Randy and Kay Parker, who live across the street from the project in a custom house constructed on A-zone property. Comments focus on the loss of their property values and aesthetics. In a recent submittal from them, including a letter received today from their lawyer, Richard Harriman, they continue to raise issues regarding potential impacts from flooding, earthquakes resulting from the pile drivers used in the solar construction, inconsistency with the Kern County General Plan, and an opposition to conversion of farmland. We have provided detailed responses to all of these, not only in Volume 3, Response to Comments, but in a staff report and in the addendum you received today, including 2 additional pieces of information, specifically from the air quality consultant who prepared the air quality analysis and the attorney for the applicant. We do have an indemnification agreement for full defense of this environmental impact report, but all of the responses in the addendum and in the staff is the staff's objective response to you. I do want to touch on some of these issues. The aesthetics. The staff report details the discussion, and you will hear testimony today, that the owners of this land, it's a family farm, and they have ran into issues in their inability to farm all of it. They have to leave some of it fallow and farm the rest of it. They would like to keep this land in their family, and they believe that the solar project is a way for them to acquire the funding so that a portion of it, 80 acres of it, could remain as farming. The rest of it would be used as a solar project. The issues of aesthetics have been raised by Mr. Parker and his wife, who live across the street. And I'd like to point out that while your board can require on this solar project certain types of mitigation and conditions to address issues in regards to aesthetics, if this landowner wanted to cover the entire 200 acres with farm buildings, it would not go through a public hearing. They would come to our public counter and we would give them a permit. There's no landscaping required for those kinds of buildings. There's no consideration of fencing. And in reality, this is an agricultural area, and this property could actually be converted and would not be farmed at all and converted to agricultural buildings with no discretionary standards. As for flooding, we do have Chuck Lackey here today from Engineering and Survey Permit Services. We have verified this is not in a flood zone. and they will be reviewing the drainage plan to ensure no increased off-site impacts. Once again, that does not apply to normal agricultural practices. In other hearings that have been before your board, you've heard of complaints from neighbors about agricultural flooding. This project will have mitigation that requires that they do a drainage plan, and there will be no increased runoff. However, in agricultural areas, farmers can go out, they can grade the land, and there is no discretionary drainage requirements. If there is a complaint, we will go out and look at it, but in reality, there are more protections from flooding, possible flooding, or off-site drainage with this solar project than there is with leaving the land as farmland. Staff notes that when you build a house in an area zoned agricultural, it means the homeowner may be subjected to smells, noise, unusual traffic that they otherwise wouldn't be subjected to in a residentially zoned area. And our zoning ordinance was not designed for those kinds of protections. I will speak in a little while when we talk about the Planning Commission recommendation that we have imposed conditions, however, that we do believe mitigate some of these impacts for the owners of the house across the street. Mr. Richard Harriman, an attorney, submitted comments this morning representing Randy and Kay Parker and Kern County Advocates for Agriculture. The letter and our detailed response is included in the addendum provided to your board. The letter contains incorrect statements regarding the information about the project in the final EIR, and also is incorrect on the policy direction that your board gave staff last July on solar PV projects and potential farmland conversion. Contrary to Mr. Harriman's statements, your board never directed that the policy be incorporated into the Kern County General Plan. There's no state law that requires that your board do so. Your board further identified 9 projects that would be exempt from the pathway, both in the valley and the desert area of Kern County. So it's a total of 9 for the entire county. Orion Solar is one of those projects in the Central Valley. Therefore, this pathway does not apply to this project. However, discussion of the cumulative impacts of all projects in the valley and ag conversion was included in the final EIR. Your board gave staff direction at that time that these projects would be considered on a case-by-case basis, keeping in mind that the site-specific aspects and the cumulative impacts. In the addendum that you did receive today, I'd like to review for a moment some information about valley area solar projects. Your board gave clear direction to staff that you were concerned about the sensitivity of the Edison area. So I have provided statistics that show the breakdown of what we've already approved. And if we could have the map that shows where the Edison area is. So we have approved in the valley 9,429 acres of solar projects for a total of 1,051 megawatts. Of that, 6,890 acres is farmland. However, it is not all productive farmland. 5,000 acres of it, that was the Maricopa Sun project, which is on the west side, which was determined to not be farmable and hadn't been farmed for 9 or 10 years because of salinity of the water and complete lack of water. It was designated as farmland on maps, but we made the determination through the environmental impact report that it was not. In addition, there is the Edison project that was approved by your board called Regulus, which was 763 acres of prime farmland. So of the total, 1,077 acres of farmland has been converted in the valley through commercial solar projects. That was actually farmed land that could be farmed. Proposed in the valley, we have 7,065 acres of proposed projects. This is on page 2 of your addendum staff report. However, only 386 acres of that is farmland, and it is not in the Edison area. And I am emphasizing that because your board was concerned about the microclimate of the Edison area. You were concerned about the specialness of that microclimate for different kinds of crops. And you did indicate that you were interested in us looking at these on a site-by-site and case-by-case basis. So to recap, this project is not in the Edison area. We have only converted 763 acres, one project that your board approved in that area. And at this point, we have no other projects with applications proposed in the area. And if Ms. Kitchen could outline the Edison area, we use the Edison School District boundaries, since there's, concludes the town of Edison. And if you could then indicate where this project is. This project, Orion. Another map. So once again, Regulus, this is Orion, the project you're considering today. Regulus is the project in the Edison area that had previously been approved and had been, there had been much discussion during the pathways and during that proposal. Written findings and a brief explanation of the rationales for these findings have been provided to your board as attachments. They include Section 15091, Findings of Fact, Section 15093, Statement of Overriding Considerations. We have provided the details for the Statement of Overriding Considerations, which provide the economic and social benefits of the project outweigh the unavoidable and significant environmental impacts that remain. These are your findings to make and your findings to expand or otherwise ask questions about. Project will provide 250 construction jobs and 2 permanent jobs. But as the property is currently under a Williamson Act contract, they are paying a reduced valuation. Construction of the solar project does require the immediate cancellation of the contract, which returns the value of the underlying land to current market rate. It is not true that these projects pay no taxes. They do pay taxes, but we cannot reassess them for the value of the solar panels. Therefore, the land will once again be valued at its normal rate, not a reduced rate for the Williamson Act. And the estimate is that over 30 years we would recoup an estimated property tax of $1 million. And in addition, there would be a one-time sales tax to the county for the panels of at least $1.5 million. That exemption, of course, is still in place. However, over the 25 to 30-year lifespan of the project, it is possible that the legislature may release that, and we would be able to reassess it. The operations and maintenance building on the Regulus project is not exempt from that and would be reassessed based on its value and its building, and therefore the O&M building that's associated with this project, although in another location, would pay more property taxes. This project, as a renewable energy project, does have a memorandum of understanding. This is to protect the county and your board from the possibility that the project could be sold to a city or county or public utility that is exempt from your jurisdiction and authority. The Government Code, Section 53091, does exempt such entities, and they would be able to remove all the mitigation and remove the conditions. This memorandum of understanding between you and the applicant requires that if they sell this, that they sell it subject to this agreement, and therefore the city or whoever buys it would be subject to it. This has already happened with the City of Los Angeles, and on this particular issue, the City of Los Angeles has not objected to that and is complying with all of your board's authority. Part of that mitigation requires that if they also are exempt from paying property taxes, that instead they're going to pay $1,000 a megawatt directly to the county every year for the life of the project to make up for the fact that they are exempt from paying you property taxes. This project was considered at a Planning Commission hearing on March 28th. Members of the public spoke in support of the project included the president of the Electrical Workers Union, the Arvin School District, and the Kern Economic Development Corporation. Mr. Parker spoke in opposition to the project and raised his concerns regarding flooding, loss of property values, loss of productive farmland, and the economic benefits that farmland brings to the county. In response to the concerns of Mr. Parker, the applicant had redesigned the project to move it back 60 feet and committed to putting in landscaping and screening. Normally, we don't require that as mandatory in an agricultural zone. However, given the concerns, the Commission applied this new standard and did make it mandatory. It is now a condition of approval and will be fully implemented by the Planning Department. With Commissioner Bellamini in opposition, the Commission voted 4-1 to recommend approval of the project. After consideration of all the issues and this comprehensive environmental review, the staff and the Planning Commission is recommending approval of the project. It's located on land that has been determined not to be fully usable for crops, and the owner of the property is actually out of compliance with the Williamson Act contract. The area is outside the sensitive Edison farming area. It's proximate to transmission and PG&E capacity. We do recommend approval of this. We think it is appropriately cited, sufficiently mitigated, and consistent with the policy of your board to support economic growth, job generation, and to support landowners in finding productive uses for their land. When you're ready, the Planning Commission recommendation is in your addendum staff report. There's only addition of one bolded word, and I would be pleased to provide that at some point, and I'm available for questions. Thank you.
Thank you, Ms. Oviatt. Members of the board, do you have any questions before we go to the public? Supervisor Perez.
Thank you. Are they out of compliance with the Williamson Act because they don't have the water to farm all the land?
Supervisor Perez, through the chair, that's correct. They're doing the best they can by rotating crops from one end of the property to another, but at some point it does not fully comply with the Williamson Act.
Any other questions by the board before we go to the public? Okay, this action and its recommended action back to the board requires, and we are happy to conduct a public hearing. So you and the public are now given the opportunity to comment specifically about the project, and there are several recommendations that range from adopting the recommendation from the Planning Commission, certifying an EIR. There's a long list of things here, but the bottom line is that the recommendation is to approve and make all the findings and changes necessary to accommodate the approval of this project. So we're going to hear first this afternoon from those who are opposed to that recommendation, and then we're going to hear from those who are in favor of staff's recommendation. So if you are here today and you would like to speak in opposition to staff's recommendation to basically approve and facilitate the development of this project, I'm going to give you a half an hour, 30 minutes. We're going to start the clock here in a moment to be able to make comment to us. And then we'll, when that 30 minutes has expired, or when those that wish to testify have concluded their testimony, if it's sooner than 30 minutes, then we'll close that side of the public hearing, move to the other side and hear from those who are in favor of the project. And then, because we want to give everybody an opportunity, because sometimes things are said that stir additional thoughts, we'll give a 5-minute rebuttal to either side, so there'll be an opportunity to speak about those items again. Okay. So is that clear? For those that are here today who wish to speak in opposition to this project, we now offer you the opportunity to come forward and speak. How many folks here today would like to do that? Okay, I see 3. Okay, very good. Would you come forward, sir? And the way that our rules work is we need each person that testifies to give us their name and their connection to the project, and then you're welcome to go ahead and make your comments.
Chairman Maggard, honorable supervisors, county staff, county council. I'm Randy Parker. I live at 3820 Herring Road. I'm here with my wife of 40 years, Kay Parker. I'm here with the other sensitive receptor on the west side of the project, my nephew, Michael Harris, and his father, Ned Harris. I'd like to make 4 points to you regarding this project and hope to persuade you to vote it down. 1, this project is proposed in the wrong place. It should not be on prime farmland. This county resource of prime farmland should not be and does not have to be traded for the estimated benefits of alternative energy. We as a county can have them both, solar and ag. This project on lesser ground or even bad ground will bring Kern County the same amount of economic benefit as proposed by the applicants and planning department, who appears to be an advocate, and Professor Fountain and his economic multiplier study. We don't have to trade 5 months of construction jobs for 20 years of farm jobs. We could move this solar project to lesser unfarmed ground, like the alkali ground just 3 miles due west of the proposed site. 2, when Lawrence Garone accepted the property tax subsidy from our Kern County citizens to join the Williamson Act back all those 50 years ago, he accepted and acknowledged the public trust and accepted and acknowledged our citizens' interest in keeping the farmland producing for the benefit of all of Kern County. You, as the board of supervisors, are the fiduciary for that public trust. And approval of this project will breach that public trust. Now that the heirs of Lawrence Scroney want to retire, they reject the public trust for their own betterment. It is incumbent upon you to shoulder this burden of public trust and shield it from breach. You don't have to let them cash out on prime farmland. 3, at the Board of Supervisors meeting last December, where your board approved the conversion of 1,763 acres of prime farmland in 2 different solar proposals from this same applicant, you voiced concern about the domino effect. And that is more applications for solar projects on prime farmland that surround the county's PG&E substations. You were assured by the applicant that these projects simply used up excess capacity at the substations. And so once that was absorbed, there would be no further applications. Well, here's your domino effect. On page 3 of your staff report, on the bottom of the page, you can read it. You'll see your planning department proponent leaning doublespeak, where they tell you that the existing facility has the capacity, but PG&E may have to reconduct or not reconduct, Lorelei. And that means they got to put new conductors on the poles. But when they reconductor to accept this new load, that means they need new conductors. The new conductors mean they need new lines. And the new lines mean they need poles. But it's just for 9 miles. Here we are using non-existent excess capacity as an excuse to convert prime farmland. And we're having to increase infrastructure to accommodate it. This is not excess capacity being absorbed. Don't let them take our best ground. They can do this project elsewhere. 4, your staff report justifies this project with a 1-to-1 mitigation. They tell us the applicant makes a deal with Rosedale Rio Bravo Water Storage District. What they don't tell us is whether the proposed Rosedale Rio Bravo swap ground is prime, whether it's in production, whether it can even produce crops, whether there is enough water to farm it. Rosedale Rio Bravo doesn't have the water to farm all the acreage they've already got. As you know, they are currently suing the Kern County Water Agency over lack of groundwater, and their state water project water is scheduled at only 30% this year. How can that mitigate some of the best carrot ground in the world, served by plenty of the best water available? Yes, the applicant will tell you landowner has not maintained one of his wells. He has not maintained it. It's there. He may need to drill another one, but it's there. He's been pourboying it, and he's using that as an excuse. So applicants suggest, well, there's a shortage of water. There's no shortage of water there. This is bunk. My well is directly across the street with plenty of good water, not too deep. And the subject property is also in the Arvin Edison Water Storage District. The landowner could get a turnout upon his request, but he hasn't. Let them mitigate an inferior non-prime farmland location with the inferior thirsty Rosedale swap ground. In closing, what we have here are landowners wanting to break the public trust and cash out. If you let them, and a solar applicant trying to pick the low-hanging fruit in Kern County, betting that you will again shuck your fiduciary responsibility and allow them to profit handsomely by converting our prime resource. Please stand with me. Embrace your fiduciary responsibility to the public trust. Disallow this prime farmland conversion. You can always make up these 20 megawatts on one of the next 37 solar proposals that are set to come before your board, as listed in the cumulative projects, part of the EIR on page 323. I urge you to pick and choose wisely, Honorable Board. Thank you.
Thank you, Mr. Parker. Admire your marriage of 40 years. That's to be applauded. Probably your wife is to be applauded. Good afternoon.
Good afternoon. My name is Renee Nelson, RENEENELSON, and I am here to speak in opposition today. Just a couple items I wanted to clarify. I believe that Ms. Oviatt left off one of the projects that the board approved for another 160 acres. That was the Adobe. I believe you heard two at the time. And I want to clarify, 3 of the board members were not here at the time of those approvals, and maybe they didn't have a year to read the EIRs. That would be Supervisor Gleason, Couch, and Perez. And I know it's a lot of reading, and I know sometimes it can put you to sleep, but ultimately the details are in there, or they're not. And that's what we're asking you today, is to not approve this, because a lot of the details are not in there. And I'll start with the geotechnical report. We have huge concerns about the seismic for this project. It's in an active earthquake fault zone that connects all the way up to the Kern River, up to Lake Isabella, and all the way down over to the San Andreas Fault. And the report was included today with the staff report, but that hasn't given anyone, myself or any other people, time to review and digest that report, and that includes yourselves as well. That's the purpose of CEQA, is that the information is available to the public and to the decision makers in a timely fashion for review. So I would like to ask for time to review that, and I don't mean today in 10 minutes, because that's not possible. Secondly, we are talking about upgrades to the lines. I guess reconductoring is the technical term. Who is paying for this? My understanding, whenever a project's coming on, is that PG&E charges the ratepayers for any kind of upgrades to the facility systems. This should be something that is discussed in the EIR. Is it PG&E? Is it the applicant? I couldn't find it. Maybe it's in there. I didn't see it. Let's see. I want to clarify as well, the applicant is not requesting, nor is the property owner, to put a lot of farm buildings. We're talking about solar. We're not talking about different products or things that can be there. We're talking about solar. Solar does not, again, have to be an ag. I've been an advocate for solar for 30 years in this county. So I have mixed feelings to say move it. Yes, I want to see it, but not in prime ag. As a person that's grown up in this valley, I understand the value of agriculture. I understand that we feed not only the nation and the world. I understand that it's a $5 billion industry in Kern County, not including the whole valley. When you ask that the EIR look at mitigation, and they can look up and down the valley, but you don't look up and down the valley for an alternative site, that's a flaw in the process. Again, we have areas that we can put it in, but those weren't discussed or looked at within the EIR. And I wanted to reiterate the west side. There are plenty of tie-ins over there. There's a lot of power going on, generation there, and it's a good place to put it. Let me look real quickly here. I got that. I had a chance to review the December 12th meeting, and if this isn't the domino effect, I'm not sure what is. I don't know why neither staff nor the applicants at that time mentioned this project. It wasn't on your calendar, but they knew it was in the process. And when Mr. Maggard and Mr. Scribner responded, we don't want to see the domino effect, what is this? If you know that you have another project in the same area, then you need to express that in the public and in the testimony. Again, I'd like to qualify that I don't feel that the EIR was adequately detailed. I have a lot of questions that were not answered. Mr. Parker does as well. We'd like to see this recirculated, and I'm going to cede my time here. Thank you.
Thank you, Ms. Nelson. Would anybody else like to speak this afternoon? Good afternoon.
Good afternoon, Mr. Chairman, honorable members of the board. My name is Richard Harriman. I'm representing the Parker family and Kern County Advocates for Agriculture and Unincorporated Association. I want to thank staff for the very quick turnaround that they got on our comments. That's why I sent them by email, so they could get them out to their consultants. I'm going to comment on a couple of areas in order to focus very narrowly on what I think the real issue is before your board. Your board is facing a very difficult policy decision relative to the conversion of agricultural land for the expansion of the renewable energy industry. Like Mr. and Mrs. Parker and Ms. Nelson, I'm very pro-solar, particularly PV renewable solar. Very much support it, have spoken for it in many other venues than here today. What troubles me about this case is that it's really a land use case. It's not just an environmental case. It's really a land use case. And my primary concern that I addressed the board about this afternoon is that you are going to be creating a very bad precedent for land use planning in this county if you approve this project and others of its like. The reason for that is that as a staff report, an environmental impact report candidly admit this is really an industrial use. It has no relationship to agriculture. It does not provide any benefits to agriculture. It takes away economic activity from the agribusiness industry that supports agriculture in Kern County and in the rest of this San Joaquin and Central Valley. The issue regarding the industrial use means that if somebody else comes along and says, well, this board has already allowed a special industry to go ahead and be able to convert agricultural land, prime, unprime, to non-agricultural uses for a magnificent profit to the applicant and to be used in an industrial way that doesn't serve agriculture. I'll go back to a comment that Ms. Oviatt says, and I always listen very carefully to her. She's very, very competent. But I think that the buildings on 200 acres, as Ms. Nelson suggested, is a red herring. If you were going to have an agriculturally related business out there, say a poultry grow-out facility or some other agriculturally related facility that actually served agriculture, you still would have to go through building permits, you'd have to go through other discretionary review issues, site plan review issues. It does get reviewed. It doesn't just get approved as a by right. In this particular case, however, what you are setting up as a potential here for Kern County is if the economics of this are truly what the economic study says, why would anyone want to continue to farm here? Wouldn't we want to exchange every single acre we possibly could of flat, arable ground into solar panels? If we can make the kinds of profit that they say, and if it's really going to benefit the residents of Kern County, as they say, then this particular project and this precedent sets a cumulative impacts policy in this county which has not been analyzed in your general plan, has not been considered as a proposed general plan amendment as the discussion concerning the path to process was discussing. You're in terra incognita here in terms of your policy and your development policy. You're really hitting agribusiness in the nose. You're punching them in the face. You're saying, you're not worthy. You don't produce enough. Your industry is not providing enough profit, jobs, multiplier effects to the community here. We want more. We want you to give up your land so we can have more. The other thing that's very interesting in this particular project and the others of its kind that are addressed in the EIR is this project benefits the landowner, it benefits the project applicant, it benefits the purchaser of the power in San Francisco. What benefit does it provide to the individual residents of Kern County on an economic basis of its own? Once again, we are seeing essentially an economic imperialism being foisted off on this board and this county, saying, oh, we're just going to take your resources, your open land, your prime agricultural land, we're going to take the sunlight energy that comes in, we're going to process it, and we're going to export it out to the coasts and the other areas which need the energy. There's no mention in their project proposal of a reduced rate for Kern County residents for this new renewable energy. There's no proposal that agricultural pumping wells would be able to be using this energy from these folks. There's no suggestion of that. There's no suggestion to the people whose impacts are going to be felt in terms of aesthetic and scenic values. Those folks aren't being offered free panels on their roof. They're not being offered anything. So the only people who make any money off this are the landowners, the applicant, and the contractors that they hire. Mr. Parker stole my point, which is, why would you settle for 5 months of 125 jobs for a decade, 2 decades of the waste of agricultural land? Your one-for-one mitigation proposal in this particular project is laughable because it's not committed, it's not told to us what it's going to farm. It's going to end at the end of 20 years when this project does. So there's not really any permanent preservation of the agricultural land that is proposed to be converted here. That moves me into the discussions on the general plan, which I think are very important. And I'm going to spend most of my time on that and the alternatives analysis, because I think those are the real policy issues before you. I'm not going to address the economic study. And the reason I'm not going to address that is the only relevance that that economic study brings to the table here today is for the public benefit argument on the Williamson Act cancellation or partial cancellation. That happens to be an argument that has a standard of substantial evidence. Those of us who've been through this before, including your legal staff and planning staff, know that even if I brought in an expert today and had Dr. Helmut Schmidt from the Arkansas Institute give you new economic information, it doesn't matter, because you as legislators have the right to determine which expert to believe. So what's really interesting about the Williamson Act contract, ladies and gentlemen, is the fact they didn't take option number 1, didn't take the one that requires a finding of consistency with the general plan. And they didn't take it because they didn't want to have to rely on that finding coming from this board. So in effect, on the public benefit basis of their approach under the Williamson Act, you can say your standard is, if it's not arbitrary, capricious, and so unreasonable that no human being would find it was reasonable, only in that case would the 5th District Court of Appeal or the Supreme Court overturn you. So my point is, you don't even get to that point. You don't even get to the Williamson Act cancellation issue because you can't get past the land use issues. And what staff and the opposing counsel appear to not have understood is that if you had taken the pathway to progress and you had provided it as a proposed amendment to your general plan, you would have had a hearing on it, you would have had environmental review on it, you would have had comments from multitudes of lawyers and other people, and you would have given it a full hearing, and then you would have amended it in. But instead what you did is you used it as a way to try to mitigate the inconsistency with your general plan and the inadequacy of your general plan, open space and conservation elements, because your general plan does not have a long-range plan to permanently protect agricultural land in Kern County. Let me say that again. Your current general plan is legally defective because under the Open Space Lands Act, which is incorporated in your general plan through the conservation element, you are required by law to have a permanent program for protection of agricultural land permanently. Your mitigation measures of 1 to 1 acre in this particular situation doesn't perpetually preserve ag land. It simply essentially warehouses it until it's ready to be developed. Yet you explain in your general plan, and you rely upon in the general plan, upon the Williamson Act contract as a measure which protects the long-term permanent protection of open space and ag land. It doesn't. All it does is it pushes it off until it gets developed later on. What you are doing with this project, if you make the decision and if you adopt the policy, is you are saying we are going to accelerate. We are going to accelerate the using up of ag land. We're going to make it profitable to go and have non-contiguous industrial uses put all around the open space and agricultural land of this county. You are retrograde to the values that you're trying to protect in your general plan through the land use element, the conservation element, the open space element. And as the letter from Catherine Hart said in the record, she questioned at that time, she said the very same thing, is if you want to include it in your general plan, then do it as an amendment. You didn't, but you're still relying upon it here as a means of trying to avoid the fundamental issue of using ag land up now. What's going to happen if somebody comes along and says, you know, I want to make photovoltaic manufacturing facilities. I want to have manufacturing facilities of photovoltaic panels so I can serve these wonderful PV projects that we're considering today. How are you going to say no to them? What happens if somebody comes in and says, well, I really want to use a thermal solar project. I want to do that on agricultural land. It's industrial. It's pretty close. It's very, very similar to a PV solar project. How are you going to say no to them? How about if somebody else comes in and says, I have another industrial use that's environmentally beneficial? Are you going to say no to them? You're digging yourself a really deep hole here. Now, I want to address one comment in particular that was provided by the Cox Castle Nicholson firm this today. The statement was made by the young attorney, I assume young attorney, Rachel Jones, that the general plan consistency and adequacy issues cannot be raised now because under Government Code Section 65009, subsection C, subsection 1, subsection A, you have to raise those within 90 days. That's simply wrong. The case law says that if you are going to consider a project which requires a finding of consistency with your general plan, you have two issues to address. Number one, is it consistent with the land use element, conservation element, open space element, energy element, whatever elements are relevant to this project? You are doing that. That is a consistency issue which we can raise here today and we have in our comments. The second issue, as to the inadequacy of the general plan, when you have a statutory inadequacy, you've failed to provide a mandatory component of a mandatory element in your general plan, that issue can be raised at the time of the hearing on a matter which requires a finding of consistency with that particular element. We have timely done that, and you cannot make a finding of consistency with a mandatory element if it is legally inadequate, and we've addressed that in our comments. So the statute of limitations issue is off the table, with all due respect. I want to address the alternative B issue, because I think this is an issue that, again, raises a policy matter for you. And that is, if the alternative was determined to be the environmentally superior alternative, then the burden shifts to the applicant to say, well, here's the reasons why we can't do it. And here's the specific reasons, here's the issues that we think are important. The fact of the matter is that your policy issue today is, should we go ahead and start first with ag land for photovoltaic plants, or do we want to start with ground that has already been disturbed or otherwise developed? The perfect example, I happen to just mention it because Calcott had developed their former storage yard in North Fresno to a business park, and I was aware of the other property here. With respect to the Calcott project here, if you were to go there, you would have almost a lion's share of the panel area you needed put on top of the storage areas. They might have to re-engineer the calculations, but you wouldn't have to convert ag land. Mr. Chairman, am I within time, or am I getting close to the end?
I'm just going to prompt you that you're just under 3 minutes left.
Thank you, sir.
Okay.
So with regard to that alternative, that is still the environmentally superior alternative. And as a policy, you should not allow the applicant not to use that property or that particular alternative. That's the one you really want to be using here in the county. At least 2 members of this board have constituencies within the city of Bakersfield. There's simply no reason why you can't reuse already developed urban property. In other words, to recycle urban developed property rather than going out and doing greenfield photovoltaic projects willy-nilly all over the county. I want to make one other set of comments regarding traffic and the Arvin area. It was argued in the EIR and in the staff report that the impacts are of such a temporary nature that they won't be significant. And the impacts that won't be significant are the large amount of criteria emissions that are going to be admitted during the construction phase of this project, the 5-month period. That 5-month period happens to occur during the busiest agricultural time in that particular area around Arvin and that little basin there. That area in Arvin also happens to be the worst air region in the San Joaquin Valley. So you're bringing in impacts for a short period of time. The fact that they're temporary doesn't mean that you don't have to quantify them. It doesn't mean that you don't have to look at them. And the other issue relative to traffic safety, if you look at the ag vehicles that are operating during that time of the year, along with these construction vehicles, if it's not during school, there won't be school buses, but you're going to have kids out on vacation. I suggest to you that in weighing and balancing your overriding considerations, you have not had the evidence presented to you where you can override death of children, that you can override car accidents and that are caused by the increased truck traffic. You don't have any analysis in your overriding significance findings that say that you should allow traffic accidents to occur that will be caused by this particular project. I don't have anything further. I would like to ask if there are any questions from the board.
We might have some questions after we have heard from the other side.
Thank you,
and then
Mr. Chairman.
I just want to give you one more heads up that we'll allow a 5-minute rebuttal on either side so after we hear that half hour of testimony on the other side, we'll give you 5 more minutes, and then we'll give them 5 more minutes.
Okay. Your Honor, Mr. Chairman, I didn't mention the public trust doctrine. I'll address that in the 5 minutes after.
Thank you, Mr. Harriman.
Thank you.
Okay, so that's we've consumed our 30 minutes, a little bit more than that I had set aside for those that have opposed the project. So let's close that portion of our public hearing and now shift to those that are here today who would like to speak in favor of staff's recommendation to approve this project. Are there members of the public here today that would like to speak in favor? We're going to allow 30 minutes for those arguments to be made, and then we will go into our second phase, which is the rebuttal phase. So can you give us your name for the record and what your role in this project is?
Christina White with Sun Edison. I'm the project manager for the Orion Solar.
What was your last name again?
White.
White. Thank you. Good afternoon.
Hi. I brought a brief presentation. I wanted to thank the board for giving us the opportunity to present this project, and I especially wanted to thank Ms. Oviatt and her staff for having worked with us through this permitting process. When we started this development process back in 2010, we became actively engaged in the community and became very, very aware of the sensitivities of solar development on ag land. And so we came up with a creative and unique solution that not only allows for solar to be developed on this site, but also for agriculture to continue on site as well. The entire site is actually 280 acres and is owned by the Scaronis. It's been in their family trust since 1964 and has been farmed since. One of the two wells located on site has failed to work in recent years due to mechanical issues and would require more than $250,000 to fix on top of the $100,000 already spent by the Scaronis. So due to limited water supply, only half of the site is ever really farmed at a time. So we're looking at 140 acres in the spring and 140 acres in the fall. So as it stands, the full 280 acres are never really fully cultivated. So facing retirement and wanting to seek the highest and best use of his property for their family in the near term, while also keeping their land available for future farming, the Scaronis leased their site out to us in 2010. When we started the development process, the first thing that really grabbed us is that we were concerned about the tenant farmers and what this project would do to their livelihood once approved. And so we've been in consistent communication with Left Ardellis and Tim Hong, who are the tenant farmers, and they've been supportive of the project since day one. And we wanted to see if there was a way that we could just come up with the ability to build solar and also keep them farming. And so what we've been working on pretty rigorously is minimizing our project footprint and maximizing the unused acreage to revert back into, or I guess to continue in agriculture. With approval of the Orion project, the 80 acres that are shown in red would go back, or would remain in farming, and Sun Edison would fund an irrigation pipeline extension from the working water well over to that area. So we think that this project, again, is unique because we can do solar, can keep farming, and most importantly, keep our tenant farmers there. Okay, so one of the questions that we're asked when we start the development process is why this site? Why did we select it? One of the primary reasons is that its proximity to an interconnection point with available capacity. We're going to be interconnecting to the 70 kV line that's just east of the site on South Edison Road, from the Weed Patch substation going through the Arvin substation to the San Bernard. One of the questions we get shortly after giving that answer is, well, does that mean that Arvin Edison is going to be blanketed with solar panels? And the answer is no. So I've provided some bullet points just to provide some color. You cannot simply walk up to a transmission line and just tie in. More often than not, we find that there is limited capacity for a number of issues, and we toss a project. I mean, if there's limited capacity, we have to spend a lot of money in network upgrades, which the applicant does have to pay for. Once this project is in operations, it'll effectively max out the available capacity on the 70 kV line, which is one of the central utility corridors in that Arvin Edison area just because it ties into all of those important substations. So subsequently, it's very unlikely that other projects will be built in that area. And so facing limited capacity, we're also looking at the difficulty in getting a power purchase agreement. It's been recently indicated to the CPUC by investor-owned utilities like PG&E and SCE that they have largely procured and have are very close, if not almost there, have met their RPS requirements. So again, there's no rush of power projects that are expected in this area when you have limited capacity issues and you also have the difficulty in being awarded a power purchase agreement. So there are additional reasons. We have a landowner who wishes to partner with solar. We have flat topography. We have an encouraging and supportive business community. Most importantly, we have a very skilled labor force in Kern County, which enables us to hire locally. And we have local economic partners that always come out in support of these projects. So in the stakeholder outreach process, we discovered that, well, there were concerns from the two nearby neighbors, Mr. Parker, who lives north of the site, and Mr. Harris, who lives west of the site. One such concern was as it relates to visual impacts. So we went out there twice. First time it was cloudy. Got out there within the existing right-of-way in front of Mr. Parker's house. We took some photos. This is facing southeast. The top picture is what your standard solar project would look like, with your 10-foot setback to accommodate the utility right-of-way, chain-link fence with 3 strands of barbed wire. And the bottom picture shows what we intend to do to address those concerns, which includes increasing the setback up to 60 feet, which is 6 times greater than the standard setback. Also include vegetative screening and decorative fencing. And to further reduce the industrial look, we're not going to have the 3 strands of barbed wire at all. I just wanted to point out that this is a prototype. We're amenable, and we've made it clear, to any type of decorative fencing, any color, vegetative screening, anything that's within reason that we can do. We'd be more than happy to do that. The next slide is also from in front of Mr. Parker's property facing south. As you can see, the mountain range is still visible. And this is a view facing southwest. I think it's important to state that by increasing the setback, we're able to create a balance of land to be used to address Mr. Parker's concerns with respect to visual impacts, and also land to be used for agriculture. So essentially, for every foot that we put in to providing this setback, we essentially take away from the unused agriculture. So we feel that we've struck a good balance and found a good solution. And this was taken from Mr. Harris's property. It's facing east. So from where from his property line, from where the solar facility is going to be, is actually a 1/4 mile. And in this simulation, we don't even have the decorative fencing, we don't have the vegetative screening, and as you can see, the impacts are negligible. As previously stated, we've been part of this community for a few years, and we really hope to be part of this community for years to come. We feel that we can support, that we should support where we can. And, for example, that means contributing and making commitments to the region's educational system, particularly the local school districts nearby where the project area is. We've recently, and we are supporting the Lamont School District in a summer science program this summer to send over 700 of their students to this program for a week that is co-hosted by NASA and CSU Bakersfield. We are also supporting the Arvin Union School District with the installation of a weather station and an HD camera, which will not only provide a live feed to the ABC 23 news channel, but will most importantly enable the teachers to expand their science curriculum with classes based on meteorology for many years to come. And we've essentially, to these 2 school districts, have invited them to attend our facilities and tour the facilities on a regular basis as needed as part of their curriculum as well. We're also partnering with higher education. We're funding the purchase of a solar tracking system to the Kern Community College District to be used by the Clean Energy Center for a practical application to supplement their program. We're also inviting them to tour the facilities as it helps with their training. And we have a few of them today, and if you won't mind, I would love to have them stand in support of the project. Thank you. Lastly, we're members and sponsors of multiple community and business organizations in Kern County who are all supportive of the project. And in the next slide, we have we're proud to have the support of these organizations in front of you. In conclusion, we're happy to have been given this opportunity to present the Orion project to your board for your consideration. We feel that this project is a win for the tenant farmers who get to continue farming the site, a win for the Scaronis who get to determine the highest and best use for their property, for their family, and we feel that it's a win for Kern County as well. And I just quickly wanted to address the economic credentials of those that we had prepare the reports. We had Dr. Robert Fountain. He's one of the industry's leading experts when it comes to providing models for solar benefits from all of these different projects. He has a PhD in urban land economics from UCLA. So we engaged him pretty early on. And then eventually we had a comparative economic analysis analysis prepared by UC Davis, Richard Sexton, and two others from the Department of Agriculture and Resource Economics. And as we all know, UC Davis is the foremost expert when it comes to agriculture, specifically as it relates to economics. If you have any questions, I'd be more than happy to answer.
We may have questions when we're through with the hearing.
Thank you.
Would any other members of the public wish to speak in favor of staff's recommendation? Good afternoon. Could you give us your name for the record, please?
My name is Scott Ellis, E-L-L-I-S.
Good afternoon, Mr. Ellis.
Good afternoon. I'm one of the primary instructors at the Kern Community Clean Energy Center for Kern Community College. I teach in both the solar and the wind. When we came together as a team and started that center about 3 years ago now, the vision was to get people employed. At the time, as you guys know, the unemployment rate here was extremely high. And so we came with that purpose, to train people. And we've done that. We have many of our former students are working on solar projects throughout Kern County. Many of them are now in lead positions. One of the gentlemen mentioned we can't trade 120 jobs for or 5 months or something along that line. But those jobs don't go away after 5 months. I'm a retired construction electrician. I moved from job to job my entire career. That doesn't mean I didn't have work. So to say that in 5 months these people go back to the unemployment office is simply, with all of the work coming in this county and others in California, is simply not realistic. They will go on, and many of them all have already been transferred from the Catalina project to the Antelope Valley Lancaster project, what happens to be, I believe, in another county, L.A. or down in Lancaster anyhow. So they're making that transition. So that they're acquiring skills. Many of these people, when I started to teach there, they had been out of work, many of them for almost 2 years. Some were sleeping in their cars. And so at a human level, there are skills that they acquire. They have learned things that can make them employable in the workplace. This is another project that we would ask that you vote in favor of. There are people, our students are behind me. They're looking for work. They want to be functioning in society. They want to make a good wage. And this and other projects will help them do this for now and in the future. So I would ask that you look at it from that perspective and consider my opinion and take that into account and vote in favor. Thank you very much.
Thank you, Mr. Ellis. Good afternoon.
Good afternoon, Chairman and honorable members of the board. My name is Jose Flores, and I live in 2100 James Court, City of Arvin. And I've been serving the community since 2002, and I've been new elected as mayor for the City of Arvin. But I'm here as a citizen from the City of Arvin. I support the FRV Orion Solar project. The location of this very important energy sustainability project will benefit the residents of Kern County. It is located a few miles from the City of Arvin, and it is my hope that will reduce electricity costs to our residents and those of Kern County. The area where the project is to be located will be enhanced because the land will be used for a greater purpose. I do not think that any negative consequences will result from the approval of this project. In fact, to the contrary, it will help our communities. And also, our city provides solar energy training to many people who are very interested in working in these projects. And our classes are expanding. There's a demand for people who wants to learn and work in these projects and have a better quality of life for their families. Thank you.
Mr. Flores, thank you for your remarks and for your service to our community. Good afternoon.
Good afternoon, Chairman Maggard and the board members. My name's Danny Kane. I'm the business manager for the Electrical Workers Union. And I was very glad to hear Mr. Ellis's comments because the previous speaker in opposition didn't mention the construction workers that would work on these projects and are, I hope, valued members of the community as well. He spoke of the Catalina project, and that is the project that's ongoing and just about ready to wrap up. It is 110 megawatt, and that is significantly larger. But some of these wage rates and percentages are representative of what you'd get on these projects. For instance, on the 28th, I reported to the Planning Commission that Catalina had paid over $7 million in wages, and the average wage per hour of those working on the job was $30.24. Many of the people that are utilized to handle and install the panels are typically unemployed, underemployed, and we have formed an alliance with ETR and the Kern Community College District. There is a diversity of ethnicities, and several of these people were exposed to the building trades who might not have been exposed to that building trades and introduced to careers, good paying careers. And we personally have taken in several into the electrical apprenticeship. I know it was very important in that the Board of Supervisors wanted 25% local hire, rightfully so. And I just wanted to let you know that for those people employed at the Catalina project, and that window in time was 274, 62% were residents of Kern County, and 77% were residents of Kern and adjacent counties. So these are good projects for construction workers who are, I hope, valued members of the community. I know that one of the previous speakers opined that he was worried about a domino effect and opening the doors for all this stuff. That's why this board wisely decided to take these projects on a case-by-case basis. I think you will be able to control these things as necessary. And I ask you to approve this project. Thank you.
Thank you, Mr. Kane. How many others would like to speak in favor of the project? Okay, we have about 9 minutes left. Good afternoon.
Good afternoon.
Do you just pull the microphone down? Oh, there we go. Thank you very much.
My name is Pat Scaroni. I'm one of the 3 Scaronis that are the landowners of the property in question.
Good afternoon.
And as much as I appreciate Mr. Parker's passion for the wonderful ag ground that we do indeed own, I question that passion and the absence of it 15 years ago when his family owned the property next to us and forfeited their ownership. We have never wavered from being owners of such ag property. Mr. Parker alludes to the fact that this project would allow us to retire. We've never mentioned that word retire, which just goes to show how little Mr. Parker knows truly about the Scaroni family. Retire is not an option. I am a humble recipient from an amazingly generous father-in-law who gave everything he had, poured everything he had into this ground. This project merely allows me to continue the passage onto my children and my grandchildren. I don't believe the issue here is whether there's water on the property. and whether I could afford to repair the, I guess, well that I've lacked in maintaining, or build a new one. I believe the issue here is my right as an owner and my right to choose what I wish to do with the property. This is our choice. Sun Edison is and has shown a community spirit. Speakers before us have alluded to the fact of how they've already given to the surrounding ag communities. Who does that anymore? They're hard to find. So it's not only us who will benefit. We won't deny there will be benefit, but we do deny that our intent is to retire. We merely want to pass it on, and I believe we've earned that right.
Hello, I'm John Scrotty, the husband here. And basically this is what we're looking at. What is our future? What is my family's future? And with Sun Edison coming in here, it would guarantee that this ground will be passed on through the Scrotty family. We've had options, people buy the ground. Pacific Gas and Electric offered me whatever I wanted for the ground. It's not for sale. We're looking at it to keep it. And we're still being farmed, still have property that's farmed, not only in that location, but other location. So we're still actively in that farming community. But this will keep this ground for the next 30, 40, 50 years. The water situation, basically, yeah, we could drill a new well, but we haven't found $300,000 to come up to do that. But at the end of this solar system, or solar field, we should have it to throw another well in. They will form the whole ground. But with one well, with the 80 acres left, it should be more than sufficient. So, thank you for your time.
Thank you, Mr. and Mrs. Scaroni. Good afternoon.
Good afternoon, Mr. Chair and members of the board. My name is Annie Mudge, and I am the attorney for the applicant. I just want to make a couple of quick points, 3 points. First of all, there's been an allegation that your general plan is inadequate under state law. That is absolutely not the case. Your general plan strikes a balance between agricultural and open space preservation and appropriate development. You've been validly and lawfully approving renewable energy projects under that general plan for many years. Second, there has been an allegation that you cannot cancel the Williamson Act under some application of the doctrine of public trust. This is a doctrine that has been applied in a very limited fashion by our courts of appeal to coastal and tidal land and public access to that land. It has never been applied in the context of a cancellation of the Williamson Act. In fact, the legislature has provided for the provisions for when you may and may not cancel a Williamson Act in response to a petition to do so. And in this case, the county is following those criteria and is following those protocols. Finally, I'd just like to point out that Mr. Parker and his counsel, I see no reason why they had to wait until this morning to submit a 15-page comment letter. The comment period on the EIR closed on January 21st. They did not submit that letter. The Planning Commission hearing was held on March 28th. They did not submit that letter. This is a time-honored tactic by CEQA Council to attempt to sandbag your staff and your applicants, and done our very best to respond in a timely fashion to a very late letter. I just want to commend your staff for their amazing flexibility and nimbleness in doing so. Thank you.
Thank you. Are there any other members? Sorry. Are there any other members of the public here this afternoon that would like to speak in favor of staff's recommendation? We have about 5 minutes left. I don't see anyone else. Okay, one more opportunity. Those who want to speak in favor. Okay, then we're going to close the opportunity for those to speak in favor and now go to the rebuttal period. So we're going to allow 5 minutes for a rebuttal from those who are opposed to the project to speak. Mr. Parker, could you give us your name again for the record?
Randy Parker. Just want to make a comment to applicant counsel. We were noticed with this proposed project about April of last year. My brother-in-law and his son and I attended the scoping meeting. We gave our comments. We provided written comments afterward. The EIR then was prepared. I hired a lawyer, and we filed 9 pages of comments on those before the January 31st deadline. We didn't get a copy of the staff Planning Commission report till a few days after the Planning Commission, but at the Planning Commission we went and made remarks. We've been involved through this entire process. I apologize for the late filed documents today, but it took me a while. I'm one guy fighting a machine, and it took me a while to get a lawyer and get him paid and get the work done. So it was no ploy. It was just we've been involved the whole way, and I'm doing my best to fight it.
It's okay, Mr. Parker. Mr. Harriman, I think you want to make a couple remarks.
Yes, thank you, Mr. Chairman. I'm honored to be opposite Annie Mudge. It's nice to see her here. She misconstrued my statement. I was not addressing the Williamson Act public interest matter. I was simply saying that we're challenging the project on the inconsistency of the project with CUP with the general plan. We're challenging it on the legal inadequacy of the general plan. Those are both state and planning zoning law claims. We're also raising the claim under the public trust doctrine, which has specific language at 333 Cal 3rd, pages 433 through 436, which cites specifically scenic vistas, ecological values, and a number of other resource values which we claim are beyond statutory. And the reason we claim that is because the statutory provisions of the Federal Clean Air Act, the State Clean Air Act, the Valley Pollution Control District are not causing the air quality to get better fast enough. And here you come dumping hundreds of tons of pollutants in an extreme air quality deprived area of Arvin, which will impact on sensitive receptors. So that's a separate and distinct claim that has nothing to do with the Williamson Act. The other issue I think Ms. Nelson raised, and I'd like to reemphasize it, is I believe the information provided by Ms. Noviat that was included in the response to comments today was the first time I'd seen that document. I think that's new and significant information that the public should have an opportunity to hear, and I support Ms. Nelson's request for a recirculation of the EIR. The other thing I would briefly bring to the board's attention is the argument made in pages 6 and 7 on the general plan inadequacy, in which I cite specifically the purposes of the open space element and your conservation element. And our position is that your efforts to carve out an exception to allow additional removal of ag land and open space is retrograde to the statute. It's retrograde to your own general plan and is a contradiction in this board's fiduciary duty for the public trust and this board's duty as the protectors of the general plan integrity and protectors of the environmental review and state planning and zoning law process. This is an integrity issue for your board. It is an integrity issue because you are trying really, really hard to look at this closely. And I'd like to say to some of the people who spoke in favor of the project, I couldn't possibly agree more that solar jobs are wonderful. I absolutely agree with the mayor of Arvin. I agree with Mr. Ellis. But they don't need to be done here on this site on prime ag land. It can be done elsewhere in the foothills. It can be done in the desert area. It can be done in an already industrialized area. It can be done in disturbed area of the county jurisdiction west of the city of Bakersfield, west of Rosedale. It just doesn't belong at this location. And I respectfully submit that the downside of approving it is if we have to challenge the legal adequacy of the general plan and one lawyer wins. If we win, the general plan's folded. you won't be able to do any development for as long as it takes to update the general plan. That's what happened in the county of Merced back in 1988 when we challenged that plan. We don't want to be here doing that. We just want you to look at locating a policy preference which recycles disturbed land before it removes green space, open space. I really appreciate having the opportunity, and it's a privilege to appear before this board with new members that I haven't met before, and thank you very much for your courtesy that you and your staff have extended to us and my clients. Thank you.
You're welcome, Mr. Harriman. Thank you for your comments. Okay, now we have an opportunity for those that are in favor of the project to have a 5-minute rebuttal. Are there any members of the public that would like to comment in favor of the project during the 5-minute rebuttal period? Thank you for resetting the clock, Madam Clerk. Good afternoon. Was it Ms. White?
Yes. Okay. Yeah, I just wanted to reiterate that, we do think that this project is in a good location with respect to the available capacity. Again, you can't just tie anywhere. Even in industrialized area, there's capacity is already maxed out. So we do understand that there are concerns with the project. We feel that we've addressed them in terms of developing solar and keeping agriculture, working with the community and helping the county not so much in just the economic benefits alone, but also in supporting their communities, particularly their future generations in education, to learn this field and grow within it. And we're excited to be part of this community for years to come, and we hope that you support the project. Thank you.
Well, that just took less than a minute. Are there any other comments that those in favor of the project want to make during a rebuttal period? Okay, I don't see anybody, so we're going to close the public hearing and return to the board for comment, questions, and action. And first up is Supervisor Scrivener.
Thank you, Mr. Chairman. First of all, I want to thank all the speakers that are here today and those that are here that didn't speak but are obviously interested in the project. Particularly, I want to thank Mr. Parker and his wife, and also the Scaronis. You two are along with the project applicant are the most interested in this, and I appreciate the two families' passion. This is one of those unenviable positions that we're often in, where we have to choose sides between two parties that we all respect. Respect your commitment to your communities, respect your commitment to our agricultural industry in the county. I want to go through and ask staff to respond to a few of the points that were raised from some of our speakers, and I'm going to give our planning staff as well as our legal staff an opportunity to respond to any of the comments made that they feel should be addressed. One of the first questions that I wanted to ask our staff to address, it was an issue that was brought up by Mr. Parker and also by Mr. Harriman, which is why choose this particular piece of property versus others that, in Mr. Parker's words, were lesser properties. But I think that Ms. White with Sun Edison summed that answer up pretty well, and it has to do with the capacity issues elsewhere, the fact that they do have the ability to tie into a 70 kV line that does have existing capacity, and also you have a willing seller who sees obviously some benefits for themselves. But I'm going to ask Ms. Oviatt if she would like to add anything to that, or if I should just move on to my next point. Okay, moving along. I wanted to ask you to address this issue of the public trust, the Williamson Act, how the Scaronis accepted this and acknowledged the public trust. And I would just say one point about that before I turn to staff is that there is a provision in the Williamson Act to cancel the Williamson Act, and then you have to pay a penalty based on that. And so it was built for people to be able to get out if that's what they choose to do. And Ms. Oviatt, would you like to make any further comments on that?
Supervisor Scrivener, through the chair, as a reminder, this is a contract. It is a legal contract between your board and the agricultural owner in exchange for growing or producing commercial, something of commercial value in the agricultural world. You are agreeing to reduce their property taxes. I would like to address at this point Mr. Harriman's representation to you that you are required to have a program for permanent protection of ag land. I can expand when you are ready on other representations he's made in the general plan, but the government code that he quoted on page 6 does not say what he says in his letter. Section 65564 of the government code says every local open space plan shall contain an action program consisting of specific programs which the legislative body intends to pursue in implementing its open space plan. He has added the word permanent ag land into his representation. And we, in the 2004 general plan, did an extensive analysis of conversion of agricultural land, which included the Williamson Act. We said there was just little under 1 million acres, which we still have, a little under 1 million acres, about 998,000 acres of cultivated prime land. And on page 4.7-38 of the Kern County General Plan EIR, we clearly said that we intended, through all sorts of development, through any kind of development, that over the 30 years we convert 71,824 acres. And in 2004, the Board of Supervisors did an override and said, you know, we'll do everything we can not to do that, but we already have specific plans approved that are zoned ag, that are farming, you know, maybe industries will come up. And so in 2004, the board directed the planning department that every year when we do our annual report to you and to the state of California as required by law, that we keep track. So every year we have kept track. And our report is coming to you for 2012 in 2 weeks. However, from 1998 to 2012, of the 71,000 that we said we've lose, we've converted 19,000. 19,095 acres of farmland we have lost between 1998 and 2012. And we've gained 5,885 acres that were actually reconverted into prime farmland. So the representation that we are inconsistent with our general plan is not supported by the actual documents that are in the record, and we are doing everything we can to balance those. Your very consideration today of this solar project, rather than making this project, as you've made other solar projects, by right, shows that you are balancing these. So when it comes to the public trust, I would say that you are taking that very seriously, and that you have a plan for agricultural support for the next 30 years, and we are not even close to converting 71,000. I predict we probably will not convert 71,000 by the time we get to 2030. And next year we will be starting an update of the Kern County General Plan, and we'll be looking at these policies. The findings that you were making for the Williamson Act is public benefit. It is different from the Williamson Act cancellation findings that are made on certain other projects. In this, you are saying that the public benefit of a power plant and the public benefit of providing renewable energy for the state of California and achieving that goal outweighs the property tax, outweighs the allowing this contract to continue and giving them property tax reductions. However, I would also submit there's a separate layer to this, which also notes that they are having trouble farming the entire property. And the Scaronis have been upfront about that and telling you that, and are now pursuing a different approach so that they no longer will benefit from the reduced property taxes.
Yeah, I'll get to the point on the Scaronis as well. I appreciate your comments. And just to tear off of that, I wanted to address the comments that were made about concerns voiced by this board, a couple of the members here, or previous project opponents, or the previous Board of Supervisors about a domino effect. And I just want to let everybody know I don't see that occurring, because there is a limited amount of capacity with our existing infrastructure for conveying the renewable electricity. And you also have reducing demand from the power companies for the power purchase agreements to meet the renewable portfolio standard. And so I don't see a widespread conversion of farmland for solar projects or any other renewable energy projects occurring in the future. This is, as Ms. Oviatt said, this is about us striking a balance between our need for ag land and the jobs that are created there, the demand for renewable energy, the jobs that are created there, and even housing. I mean, I remember when I was on the City Council, and Supervisor Maggers and Couch served on there with me as well, and when we were building lots of homes, we heard similar comments about conversion of ag land there. It's balancing the demand of our community, and sometimes those construction projects occur on agricultural land. We had folks who were opposed to Walmarts, and one of the reasons would be conversions of ag land. And actually, I think Ms. Nelson and Ms. Harriman were there to oppose those projects in years past. Want to ask the question about the Rio Bravo mitigation, the property in the Rio Bravo Water District, the mitigation land there, and whether that ground is prime, whether there's adequate water there. Ms. Oviatt, can you address that? I don't think we've identified which properties we would be mitigating with at this time.
Certainly. Supervisor Scrivener, through the chair. Mr. Parker indicated that the staff report referenced that agreement. The staff report did not reference that agreement. That reference was presented by the applicant in an attachment they presented to us. That is not an agreement that the Planning Department has signed off for mitigation. We have not seen all the details, and therefore what we have is the continuing mitigation measure. The mitigation measure is clearly written. It is mitigation measure 4.2-1, and until all of the requirements of that mitigation measure are provided to the Planning Department with all the details, none of the projects of FRV will move forward until that's done. So once again, the staff did not reference the Rosedale Rio Bravo agreement or any of that is not our representation, and it is still open as to how this project is complying with their one-to-one mitigation. Mitigation measure clearly states that it shall meet the definition of prime farmland. In this case, this is prime farmland, Mr. Murphy? This is meet the definition of prime farmland, be of similar agricultural quality as higher as established by the California Department of Conservation. So we will be reviewing any representations that are given to us by the applicant on that mitigation agreement.
Thank you, Ms. Oviatt. Are there, I'm looking down my notes here, Ms. Nelson mentioned concern about an active earthquake fault zone in the area. You remember those comments? Or I'll ask you that, and if there are any other comments that were made by Ms. Nelson that you would like to address, and then moving on down also into comments made by Mr. Harriman.
Supervisor Scrivener, through the chair, when we received this comment, we did have Mr. Lackey look at it. The nearest fault is 3 miles away. The concern was that pile driving for the solar project would somehow trigger an earthquake. Mr. Lackey is here and has represented to us. He does not see that as any sort of concern, and we note that if that were true, then the amount of pile driving we've done for the Thomas Road Improvement Project probably would have triggered more earthquakes. And many of those are close to other faults. We have addressed this issue. We've looked at this issue, and we do believe that it is this project is not actually on an earthquake fault.
Very good. Thank you. Any other comments by Ms. Nelson that you would like to address?
Just two, I appreciate that she could only look quickly at the addendum. The Adobe project that she referenced is listed on page 2 as one of the projects that is converting 160 acres of farmland. Mr. Parker said that your board approved 1,793 acres of farmland in December. That's not correct. FRV withdrew one of those projects. So there are only 2 projects that are on page 2. The Regulus project for 763 acres, and then the Adobe project for 160. Second, these projects were discussed and presented to your board last July when you did discuss the pathway. One last comment on the general plan. The Office of Planning and Research, which is the expert in California through the governor's office, issues a general plan guidelines. It was dated 2003. When we updated the general plan in 2004, we used those guidelines extensively. We have searched on our iPad, and it can find no direction that we are supposed to permanently approve ag land. Certainly, this is an ag county. It is one of our 3 top industries, and we certainly have a general plan that will protect it. And in 50 to 100 years, we will still have agriculture here. However, the word permanent does not show up, and therefore we do not believe that our general plan is in any way deficient or any way could be challenged at this time.
And what about the concerns over traffic in the Arvin area during the 5-month construction period?
Supervisor Scrivener, through the chair, as noted in the staff addendum, a full traffic study was completed for this project. It does include all the cumulative projects, and the Roads Department of Kern County has reviewed all this and feels that we have sufficient mitigation included for managing that construction traffic.
Thank you. Mr. Harriman asked a question. He said, what benefit would this project provide to Kern County residents? And that's really what this is about. It's about us determining whether or not this project is more beneficial to the county than the current use, while obviously respecting the property rights of the Scaronis. And I'd just like to list a few that I see. First of all, one of the things that we require here in Kern County is that our renewable energy companies open a local office in the unincorporated areas of Kern, so the equipment products that are purchased are run through a local office, so our county realizes the sales tax. That's a innovative change that Ms. Oviatt and her staff brought to us, well, I guess it'd be a couple of years ago now. And it's served us very well, and it served our taxpayers and our community very well. And this project alone would be approximately $1.5 million in sales tax and also $1 million in property taxes. As we talked about, with the cancellation of the Williamson Act, the property is going to be reassessed at a higher value, and the county will see the benefit of that. 250 temporary jobs for construction, approximately $41 million in tax revenues if you compare that to the current use. It'd be about $46.5 million during construction, $1.3 million in annual economic benefit for the 20-year life of the project, and as I said, when you compare that to the current use, that's about $41 million in additional benefit. We mentioned I already mentioned the capacity issues with the current transmission lines and the limited PPAs, which I think is a good reason for us not to think that this project is going to beget other projects. I know concerns were raised about flooding. This project will have a drainage plan, and farms don't. So the area isn't in a floodplain, but nevertheless, this project has more provisions for flooding than we're going to see with the current use. It's a comparison of some provisions versus no provisions with farmland. I know the setbacks are increased from 10 feet to 60 feet, and also the applicant has committed to an enhanced screening with landscaping, and they're willing to consider any kinds of screening or landscaping that anyone might suggest, and so that I know that would be the Parkers as well. I think that it's a good sign that on this particular piece of property, not only the landowners but also the tenant farmers are also in support of it. And that brings us to the issue of the water that's on the property. The Scaronis have explained, and staff I think mentioned also, that the existing wells on the property are not adequate to allow for double cropping of the farming. They cannot farm it twice a year. They have to do one half of it one time of the year and another half the other time of the year. Mr. Scaroni came in and explained to me that in my office. The remaining 65 acres, if this is converted, are going to be able to be farmed all throughout the year. I think that this is going to allow for a portion of that property to be even more productive than it is right now. And as he said, at the end of this project, the capital that he's going to realize from payments from SunEdison would actually allow him to then construct or drill the well that would be required to utilize the entire property. And when you're doing a solar project, it's not like you're paving over ag land. These ground-mounted solar panels are simply driven into the ground. At the end of 20 years, they can be pulled out and land can be converted right back into farming. And with the additional revenue that he's going to realize, I think that he'll be able to fix that well if that's what he chooses to do. And that brings me to this point, is that this particular property owner believes that this is the highest and best use for his land. And I think that that's something that we need to respect and take into serious account. Mr. Ellis, he's an instructor at the Kern County Community College District Clean Energy Center. He made a point that these students that are, these workers that are going to be on this project, it's not their temporary jobs on this project, but they're going to go on to other projects. And I think that's important for us to remember. When we were building houses, folks would go from one housing construction project to another. And I know for a fact that there are many people that were working on homes when the building boom was going that are now working on renewable energy projects. I have A friend of mine who I know is in the construction industry, and now he's up and houses, and now he's up in Tehachapi building wind turbines. And I think that these folks that are learning these skills and working on these jobs are going to go into other industries as those opportunities present themselves. We have a requirement here in Kern County that we have a 25% local hire, but as we heard earlier from another speaker, what we're actually seeing on these projects is in the neighborhood of 60 to 70% local hire. And so our local people are working on these projects, and I think that's good for everybody that's concerned. Mr. Chairman, I believe that that's the extent of my comments on this project. I am in support of staff's recommendation. I'd like to hear comments from my colleagues, and then I'd be prepared to make a motion. Thank you very much.
Thank you. Supervisor Gleason.
Thank you, Mr. Chairman. Thank you, everybody, for so articulately offering your opinion and your thoughts on what direction we should go in terms of managing this property. I listened to Mr. Parker talk about the quality of the land, talked about the Williamson Act. He talked about the one-to-one mitigation with Rosedale. I appreciate and fully consider those factors. Ms. Nelson did a good job highlighting the EIR not adequately being detailed enough. Talked about seismic issues, upgrades, why aren't we using less prime area, and also talked about the domino effect. And most of those things I've come to understand through the discussion today and earlier this week. Mr. Harriman, you did a great job. You talked about land use case. It's a land use case, not so much. That's the consideration we should focus on. You talked about it's not related to agriculture, and you considered a punch in the face of agriculture, of what we were talking about, this economic imperialism you coined, which I thought was pretty descriptive. You also brought up a good point about local use of energy and how we benefit that. I want to thank you for your comments. On the pros, I heard Ms. White talk about her advantages. I read her brief, talked with her several times about this issue and her local economic partners. Proper mitigation, I did like what I saw about the 60-foot fencing pushback. I did like the vegetation, the fencing. I did like the vista wasn't destroyed. And I think that you're doing adequate or good mitigation to help come across the table to come to agreement. You also talked about other advantages. Mr. Flores, Mr. Ellis, and others talked about several other factors. I like the fact that the mayor of Ambont came in and spoke so eloquently about his community. And finally, Mr. and Mrs. Scaroni talked about their thoughts and their concerns about what they want to do with their property. So I took all that, I put it all together. I've come up with several answers. Thanks for asking questions to staff about things that I also had questions on. In the final analysis, I don't see adequate justification to interfere with the Scaroni's right to make decisions regarding the execution of their personal property. Thank you.
I have a couple of questions. Thank you, Supervisor Gleason. I'd like to go to our county council first. There were several assertions by Mr. Harriman and others that our general plan is inadequate, and while we heard from the planning department about their opinion, her opinion about that, I'd like to hear from legal counsel's opinion. We certainly don't want our general plan to be found to be wanting to such a level that we cannot use it to better the lives of the people of Kern County. So do you have an opinion about all that?
Yes, I do. Thank you, Chairman Maggard and members of the board. I concur with what your planning director has said about the adequacy of the legal plan, of the general plan. But moreover, despite what Mr. Harriman would suggest, what he told you was that he plans on attacking your general plan. Those were the words that he used. And I want to refer you to Government Code Section 65009 C1A. And it says, except as provided in subdivision D, which doesn't apply here, no action or proceeding shall be maintained in any of the following cases by any person unless the action or proceeding is commenced and service is made on the legislative body within 90 days after the agency's decision. And subsection A says to attack, review, set aside, void, or annul the decision of a legislative body to adopt or amend a general or specific plan. This paragraph does not apply when an action is brought based upon the complete absence of a general plan or a mandatory element thereof, but it does apply to an action attacking a general plan or a mandatory element thereof on the basis that it is inadequate. In other words, it's long past the time for Mr. Harriman and his clients to attack the general plan under Government Code Section 65009C1A. And there is nothing in state law that I am aware of that requires a permanent component to the protection of ag land. And in that regard, I concur with our planning director. I have no additional comments.
Thank you. I have another question. Thank you for that. I have another question about a question that was asked. I didn't hear. I think Ms. Nelson made this remark. It had to do with whether or not ratepayers will be caused to pay for the eventual upgrades to the power lines and the capacitors and all of that, or will that cost to be borne completely by the applicant? Can you comment about that?
Chairman Margaret, I would ask the applicant. As far as we know, it's part of the power purchase agreement that they negotiate with PG&E.
So would that be Ms. Mudge or Ms. White? Good afternoon.
Good afternoon. I just wanted to confirm that we would be assuming all costs of the network upgrades.
We being the applicant?
Yes, Senate.
So there's no cost to be incurred by the ratepayers in our area to upgrade these lines for your project's purposes?
No.
Okay, good. Thank you. I think that concludes my questions as well. Do any of the members of the board wish to make comment? I don't see anyone.
Okay. I'll punch back in.
Supervisor Scribner.
Thank you. Ms. Oviatt, would you read staff's recommendation? I believe it's the Planning Commission's recommendation with a small change, right?
Certainly. Recommend to the Board of Supervisors to certify the environmental impact report, adopt Section 15091 findings and Section 15093 statement of overriding considerations, adopt mitigation measure monitoring program, approve general plan amendment as requested, approve conditional use permit subject to revised conditions, approve cancellation of the Williamson Act land use contract subject to payment of penalty fees, direct clerk of the board to issue a tentative certificate of cancellation subject to payment of penalty fees in compliance with all other conditions contained in the tentative certificate of cancellation, approve the memorandum of understanding agreement, and recommend the Board of Supervisors chairman to sign and adopt the suggested findings as set forth in the attached draft resolutions.
Thank you, Ms. Oviatt. Mr. Chairman, that's my motion.
Is there a second to that motion?
Second.
There is a second. Any other comment or questions or debate? Okay, then let's cast our votes.
The vote is all ayes.
I know that the parties hold with great passion their positions. I'm sorry for those that are disappointed, and I hope that the project turns out to be good for everybody concerned. Okay, that is item number 3. Our next matter of business this afternoon is item number 10, and it will be facilitated by a member of our staff, Mr. Lackey. Did you get your papers? Okay. Mr. Lackey is part of our engineering survey and permit services. Good afternoon, Mr. Lackey.
Good afternoon, Mr. Chairman and members of the board. This afternoon you're conducting a hearing on a proposed resolution ordering the extension of zone of benefits 3 and 5 within County Service Area number 71 and the establishment of assessments and appropriation limits with an escalation clause for zone of benefits 3 and 5 within County Service Area 71 and determining to adopt an ordinance enacting the assessments in the area. Project location is basically Stockdale Highway and Superior Road west of in the western Rosedale area. This is a result of a development project, a parcel map, in which the property owner is proposing to divide the property for further industrial use. As part of the requirements for the parcel map, he's required to provide certain entities or services, streetlights and street sweeping, through a county service area. This is the hearing establishing that county service area. Staff has mailed out ballots in accordance with Proposition 218. We've conducted a public meeting with the property owners and other interested parties. Again, this is the final establishment of that process before your board. At this time, staff has all the ballots returned in favor, but it's still necessary for your board to open the public hearing, receive any comments. Unless there is something to change that would be presented during that hearing, staff's recommendation is you take the actions as outlined on the agenda and confirm that you have a majority of the ballots back in favor. And that concludes staff's comments.
Thank you, Mr. Lackey. So we will now have an opportunity for the public to comment on item number 10 regarding this change of this CSA 71 elements. Are there any members of the public this afternoon that would like to speak to us about that matter? I don't see anyone, so let's return to the board now for comment and action. Members of the board?
I'll move staff's recommendation.
Thank you, Supervisor Couch.
Second.
Any other comments? Please cast your votes.
All ayes.
Very good. Thank you, Mr. Lackey. That concludes our afternoon's agenda here for the Kern County Board of Supervisors. We will meet next on, let's see, what is today, the 22nd? So it'll be the 30th of April at 9 a.m. here in these chambers. So if there are being no other matters before us, I would entertain a motion that we adjourn until April the 30th.
So moved.
We have a motion without objection, so ordered. Thank you very much.